So, it's too early for you all?
No,
No,
sir.
sir. It's okay, sir.
Okay. Okay. So, without waiting for others, I'm just starting. First question, before starting this session, I would like to understand, what do you understand by patent? Anyone can speak. No. Okay. So, I have to take names. What do you understand by patent? Am I audible? Hello?
Yes, sir.
Yes, sir. Yes, sir. You're audible.
Yes, sir, you're audible, sir.
Okay. So, Kuldeep ji, tell me, what do you understand by patent?
Sir, patent is a product or process innovation. It should be first time in nature, unique in nature, and it is creation of a mind.
You are saying it's a creation of a mind.
Yes, sir.
And another thing which you have told?
It should be a product or process invention or process innovation, and it should be unique in nature. The first time in, yeah.
Is it patent? What you have told me, is it a patent? How many of you agree to this, that what Pradeep has told is patent?
No, sir. Actually, patents are the rights that we get against anyone using our invention. I think that is not discovered before.
Okay. Ananya, as per you, this is the right,
Uh,
not the invention itself.
Patent
Correct.
is an
So,
invention, sir.
right over an invention.
Both both.
Ananya, you are saying invention is also a patent.
Every invention can't be a patent unless it is certified. It is analyzed that it's not obvious or it fulfill all the parameters of granting a patent.
Okay. Antarpal?
Okay, yes,
Antarpal
sir.
ji, I
Yes,
think you
sir.
also want to add something. Just tell me.
Yeah, definitely, sir. So, sir, the term patent means so it is an exclusive right we can say granted to someone for any new product, so that the person can use or make product of that of using that specific invention or idea. Basically, the term it exclude other person from using the similar invention or same invention.
Okay. 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 Antarpal ji, noted. Madhurika ji.
So patent is basically an invention idea for a product, process, or a machine or a system which gives an inventor an exclusive right uh, over his or her invention, and which can also be used to stop others from making, using, and selling the same. And if they does so, he can claim some uh,
Okay.
money or royalty out of it.
Oh. Dr. Gopal Mandal.
You said we can define patent in different way. Like in brief, anybody wants to know about what is patent. So I will tell first that patent is just a technological documents to give the patentee as a right to use, sell all kind of things for 20 years gives the monopoly. And also I can call as that negative right to keep away all the people for 20 years. And in another way, I can tell that a patent is an invention, like not that thing. So, which has the three part: the novelty, inventiveness, and the technical enhancement.
Okay. So you all are slightly correct and slightly incorrect. This is like everyone has seen the elephant and everyone is describing the elephant in a different way. For some, it is a pillar, for some, it is a rope. So let me just start with that. See, patent is, as Antarpal has rightly said, it is an right. In right, what is important is it is an exclusive right. Exclusive right over what? Exclusive right to exclude others from practicing its invention. Practicing, when I'm saying, it includes making, using, offer to sell, import. These 5 things. Make will go away if it is a process. Total 5 things. This is what your right is under section 48. Now, your right is to exclude anyone who does not have your consent, or you have not authorized them to do to work on that invention. Then yes, that is what patent is. What when we talk about creation of mind, that it is a part of product and process, it should be unique. We are not defining the patent. We are not defining the right associated with the patent, but we are trying to define the invention. Invention is a creation of mind. Invention is a product and process. Invention is unique. Okay, I think that's the problem. My background is a blur and white. That's anyways. Next comes Ananya, you are right regarding the right. Another thing which has been specifically said, that is it is a techno-legal document. No, see, it's a when you how you get a patent, right? Government recognizes your right and gives you a certificate. That is what is patent. After that, the recognition by government. That is the first thing how you get a patent. So techno-legal document is the application which you file, in which you are providing rights and other things. Patent is not a techno-legal document. What Gopamandalji has said, that it's a negative right, that is absolutely correct. Term, you all know correctly, that's a 20-year term. Now, I will start from today. What I will first talk about is the history of patent law in India. The history of patent law in India is necessary to understand how present Patent Act has evolved. You can expect 1 or 2 MCQ here, not more than that. But most important thing which will help you in this, why evolution I'm teaching you, is once you get to understand what were the circumstances which has forced our legislators to have this kind of a legislation, it will be easy for you to try to understand the provisions. Okay, because of this kind of provision we have. That's why evolution needs to be understood. So, and before going to that, the basic of patent. Why government gives you a patent? You invented something. You go manufacture and sell. Why government is bothered to protect it? Any idea? Amutanji.
Sir, it required proper rights to do the work, so others cannot copy the inventions.
See,
It will give you
what
proper
you are
rights.
trying to say, let me rephrase it. First, please don't use copy with patent. Copy will go to copyright. See, make, I said no, make, use, offer to sell, import. These are the 5 things which are associated with patent. So you focus here only. Anything subcontract manufacturing and other things will come under this. So first thing is very important. Don't use copy and don't write copy when you are writing an exam. So patent is an exclusive right given to you. Why? The question is why? Why I'm interested in giving you that? Why should I recognize that right? You are anyway making your invention. You can go and sell. If someone, why I need to protect this kind of a right? There are, for example, Coca-Cola. They are still manufacturing their invention. That is their trade secret. They are not telling it to anyone. What is the composition? They are not taking any patent. They are continuing. So,
Hello, sir.
yes, Ananya.
Sir, actually, these rights give government very um, every country is looking for technical advancement in medicines, other in technology. So these rights allow government because there are many inventions going to arms, missiles, and everything. So these patent rights help government for their revenue, economy, and technical advancement. That's why they give us right, and so that they also know what are the technical advancement, and they can also generate a revenue from this.
Ananya, are you running?
Oh, yes, sir.
Okay.
Sorry, sir.
Because no issues. Okay. See, when I'm talking about the patent, let's understand the basics of all intellectual property. In general, trademark is different. In general, every IP is creation of mind. Right? Trademark is also a creation of mind. You create a logo, you this. Similarly here also. Now, intellectual property means property created by intelligence. Now, the one line I will say, quid pro quo. I am giving you because you are doing something for me. Patent or copyright or any other form, for example, design also, I am protecting your right. I am creating a right for you because I want you to disclose it. If I don't give you this right, you will not tell me how that is being manufactured or how you have created that particular technological advancement, how you have done that. You will not tell me. You will keep it as a trade secret. You will not share it with anyone. So no one will get to know any good medicine, how that is being produced. And after you, suppose something happens, that knowledge will die with you either, or it will be concentrated with some people only. So government is saying, in order to promote the dissemination of disclosure of the invention, disclosure of your work, disclosure of your shape and design, anything, what I want, I will protect your right for a limited period of time. That limited period of time is at present 20 years. So the idea is, please note, patent is given to given because you are disclosing it. For the disclosure, you disclose your invention, I give you a right. This is the basic. That patent is being given for disclosure. It will come again and again, and again. What you are doing when you are going for complete specification, you are filing, you are telling them that this is the disclosure. The best method requirement is the disclosure. How you will approve the complete disclosure, full disclosure requirement, sufficient disclosure requirement, all those disclosure requirements which are provided in the law are nothing but the first step from you, only after which a government can recognize the right for it. Before that, government cannot describe. So the first understanding that why patent is being given to you is that you are disclosing it to the society, public at large, and public and society must be benefited from your in disclosure that invention you are giving. That's the government's motive to recognize your right, go for to make a law to protect your right with respect to patent. Okay. Now I'm sharing my screen. Do tell me if you can see this, my screen. Is it visible?
Yes, sir.
Okay. See, how many of you remember 1857? Know anything about 1857?
So make a double click, sir, in that.
This will go full screen this much only, I think.
Okay.
So, history of patent law in India. What happened in 1857? Anyone remembers?
First freedom fighting, sir.
Yes. This was the first struggle, as historians have said, 1857. This is 1857 is a landmark which separates the rule of company from the rule of crown. Before 1857, East India Company was ruling us. Crown was not ruling India at that time. So there was only Crown was not interested. Company was trying to manage Indians' affairs. But after 1857, Crown realized, okay, something is wrong. We should interfere directly. This is the watershed development. Before that, so there is a period of exclusive privilege before 1900. Just remember it as like this: before 1900, it is a period of exclusive privilege. What is exclusive privilege? Exclusive privilege was that I will give you exclusive privilege to particular invention for very less time. It was not to 10 or 12 years. It was for one or I'm not remembering the exact term, but it was less than 1 year or 2 years, 1 to 2 years. That's how it is. Now, in 1856, the first legislation in India related to patent was done. It was done by under the company administration. However, every act which was supposed to be passed should have been passed with the approval of Crown. Otherwise, it should not have been effective. So in 1857, when the Crown started to take interest in India, then this act was repealed because this act was without approval of the Crown. And in 1859, the Exclusive Privilege Patent Monopolies Act was implemented. It was based on the UK Act of 1852. So in start, what will happen is we don't have very unique act for ourselves. Whatever was in UK, it was getting extended to us. Or any act which we are making is based on some law which is made in UK. Now, then 1859 Act was consolidated to provide the protection of to design. The first 1859 Act was Patents and Design Protection Act. Then it was consolidated in 1872. Then in 1883, Protection of Invention Act was passed. It was the protection of novelty of invention against exhibition. Okay. If in any exhibition invention is disclosed, then also novelty will be protected. So it was nothing but an exception to the novelty concept in 1883. Then in 1888, 888, Invention and Design Act, the Design and Invention Act were consolidated. That means in today's term, Patent and Design Act were made one in 1888. Then the period of patents starts. This was a period of exclusivity. exclusive privilege, then the period of a patent. Period of patent starts from 1911. In 1911, Indian Patents and Design Act 1911 was passed. It replaced all the earlier act, patent administration and brought the patent administration under the management of controller of patent. See, so our initial, the very first act in which patent and designs were recognized, it begins from 1911. It says that, so all the earlier act, whatever we had done, will be taken out. Then controller of patent will become an important position, and all patent administration will come under this. So this is a creation of first time controller of patents with power. Then comes post independence. What happens in post independence? It was, say, once we got independence, we wanted to understand all the laws, streamline the whether they suit us or they were more suited to British need. On basis of that, we wanted to rationalize our laws. If it is needed, we will amend. If not, we will repeat. This was the main thing. So a Bakshi-Tekchand committee was formed. It is known as Patents Inquiry Committee during 1948 to 50, immediately after the independence. Then in 1950, it asked for the amendment of the 1911. What they asked? They asked that any invention, we should be informed of whether the invention are being worked upon or not. Should I continue the production for you or not? This is the working of invention they wanted. Second, they said that food, medicine, insecticide, germicide or fungicide, a compulsory license should be provided. Now, just a background to it, when India got independence, the initial days, we didn't have the food security. If you remember, we were not in a good shape when British left us. So what we were focusing on, building industry at the same at the same time support on the agriculture, so that food security should be there. So Green Revolution, you might remember, the Green Revolution was around those times. We were trying to, so the focus was that people should get food and medicine. This was our basic priority at that time. So that's why compulsory licensing with respect to food, medicine, insecticide, germicide or fungicide. This is out of that necessity that we went for a compulsory license. Here, before going to any other place, I will ask you, what do you understand by license? Any clue?
The transfer of ownership, sir.
Transfer of
Ownership.
ownership. Okay. Any other guesses? No. Okay. So what is assignment? This is also a term you would have heard. He is assigning something to me. He has assigned his rights to me. Music rights have been assigned to me.
Sir, here not ownership transfer. I forgot exact the transfer of like I am giving the permission, but I am not transferring my ownership.
Okay, now you have got the correct word. See, whenever we are talking of assignment, we are talking about the rights. When you are transferring the rights, that is the ownership of rights of anything. So when you transfer the rights, our rights are getting assigned. That is what your assignment is. When you are giving someone the permission to do or not to do something, that is the license. License is a restrictive practice. A license is like whatever I have said, you have to work within that boundary. Right is I am replacing you and now I have the right, you don't have any right. That's why license will always depend on the conditions which have been prescribed under the license. This is the basic difference between assignment and license. Whenever we are talking about assignment and license in patents, we will remember this fact that when I'm saying assigning, there is assigner and assignee. Assigner, the person who is assigning, assignee who is getting the assignment. Then when I'm talking about this license, then I'm talking about licensor and licensee. The person who is licensing is the licensor. The person who is getting the license is the licensee. This concept will come again and again, and it will be very important in two chapters. First is the assignment, how and license for the working of the patents. And then another one will be compulsory licensing, how government is taking your invention. The license is when you give a license, you get a license fee or a royalty, however you structure it, that's how you get the money back to us. So when you are inventing something, you want to earn. So when you are going for commercial utilization, transfer is the complete done. I don't have anything. So that is that you have washed your hands out of it. That's it. But in license, you are still involved. It's a regular income which is coming to you as a license fee. This is what license is. Okay. Now, license. Fine. Then we go for this. Then in 1950, after this amendment, 1957, we again went back to this. Let's look back to the patents, what is happening. So Justice N. Rajgopala Iyengar committee came and they submitted a report in 1959. This is a very important committee report because it gave you the present act, the Patents Acts 1970, which we are at present studying. So the Patent Acts 1970, it replaced the 1911 Act completely. If we remember what the in the first instance, what do you notice here? What is the first thing which came into the just by the name? The earlier act was known as Indian Patent and Design Act. It is known as that Patents Act. That means we are not talking about design now. Design will get its own separate act. Patent have got their own act only for the patents in 1970. And in 1970, they went for the making of the patent rules. And it is with effect from 20 April 1972 that this act came into the existence. Now here, my question is, what is different between act and rules? Because you will always be reading this.
So,
Patent
sir,
acts, patent rules.
acts means it is got passed through legislature.
Okay.
And rules
rules?
means these are not passed by legislature. It's just they are framing the rules. But when the rules are passed by legislator, it becomes an act.
Okay. So who makes the rules? Anyone can make the rules?
Central government. Central government.
We have an advocate here, right? Any
Yes,
advocate?
sir. So actually, Act is a document which is prepared by the government. Rules are also prepared by the government. Act is going to describe you what the purpose of that particular legislation is, and the rules are going to basically be a secondary legislation or a secondary document to the main act, stating that कि इसको conduct कैसे करना है, इसको implement कैसे करना है, इसको exercise कैसे करना है. So rules are secondary to act.
This is correct. What you have said, that rules are secondary to act. That's it, correct. But who makes the rules?
Government ही बनाती है सब कुछ. इसलिए टेबल्ड इन द पार्लियामेंट.
एक्ट भी गवर्नमेंट बनाती है.
सर सब पार्लियामेंट में हो जाता है. It's all done by the parliament.
Okay, I will correct you here. See, any law which is being made is the power of only one person, that is legislature. Parliament or state legislature, they have the power, they only have the power to make the law. Now, problem with that is okay, not everything can be codified, discussed in parliament. So what parliament or state legislature does, that they will give you a broad line. They will give you a broad line, and when that is passed, assented by president or governor, depending on if it is a state act or if it is a central act, depending on that, once it is assented, it is known as act. This is the broad guideline. As it has been rightly suggested that it is a secondary legislation. But why it is a secondary legislation? Because the rules are made. See, please remember, act is not made by government. Government, when I talk about government, government means executive. Legislature makes the law. Executive implements it. So government does not make the act. Government is not there as a government there. They are as a member of parliament there. Since they are part of a government, because we have that kind of a government where government is also responsible for making of legislation, but they are making it as a legislators, not as a part of government. They are not working as an executive in parliament. So act is made by parliament always when we talk state legislatures, and they delegate their function. They give their functions to this government, and then this power which is being delegated, because of that delegation of the power, they get the right, they get the power to make the rules. For that, every act has a provision. For example, in Indian Patent Act, if I have not written here, you cannot make the rule. The power has to be delegated here. So power to make the rules. Every act in the last, please see. Power of High Court to make rules, power of central government to make rules. So we have given even High Court to make the rules, depending on for their own proceeding. They will make the rule. Power of central government to make rules, that may by notification in official gazette, I can make the rules. And what is the power delegated is here. All this entire para is the power which has been delegated to you. If you don't have the power, you cannot make the rule on that particular subject. Then comes, see, rules to be placed before parliament. Unless rules are being made, but rules are supposed to be laid before parliament. If parliament or state legislature is not accepting it, they cannot become the rule, because I have delegated the power. So I have to consent to what you are doing. So without this, rules do not have that effect. But what happens is government notifies it and says that rules are coming into effect, and within 2 or more successive scales. So the earliest session which will happen, I will lay before the parliament that I have done that. Parliament does not have that much time at present, but just goes through it and gives the assent. That's how the rules are being laid before the parliament or any state legislation getting done. So this is correct that this is a secondary legislation, but rules are always made by government. So the department which makes the rules for patent acts is the Department of Industrial Promotion. Earlier it was known as promotion, DIPP. Now it is known as Department of Industry and Internal Trade, I think. Something they have changed. See, this Department of Promotion of Industry and Internal Trade. Now it is DPIIT. This is the department, and this department comes under Ministry of Commerce and Industry. This is an important piece of information. Please note, you might get an MCQ on that. Under which ministry you are working, or under which department Patents Controller General of Patent Design and Trademark works. So this is very important piece of information. Now, so that's what we discuss here, Patent Act and rules. Now we are going, let me speed up.
Here I have one question. So
Yes,
the rules that easily can change. No,
yes. Just see, the rules is they are dependent on the office which is working on this. For example, Controller General, he knows what is needed, day-to-day affair, what is needed for us. The forms are prescribed in rules, and if there is any problem in day-to-day problem, he is expecting another form is needed. He can create a form and tell you, okay, fine, this is the rule. Under this rule, this form will be applicable. The fee will be decided by the department itself, the government itself. It will get assented later, not a problem. We are not worried about it. That is an internal part. That is a legal part, how government functions. But for you to understand, the only thing is the rules are given by the department. So the notifications by department becomes important where you will search. Okay, in order to be updated, I should be following this department. Okay, these rules are coming. For example, at present, a draft rule has been circulated. So this is a new practice we have started in recent years, in last 10 years only, that we have gone for a draft rules. We give the draft rules, we ask for public comments, and then we accordingly finalize the rules, so that people are also participating and giving their idea ki what you are thinking is correct, and in this way a little improvement is needed. This is also an area where rules should be made. That's why there is a government and people dialogue. So if you are interested, if you have any suggestion, you can go and give suggestion to the draft rules which is being circulated, and you are asked to tell your view on that. Anyways, so this is the act and rule relationship. Why I'm explaining this? Because this will give you a good idea how to structure. Why, when we are talking about ki section ke baad, after section, you have to tell me the rule and this and that. This is the reason that law is not getting complete. You are not telling me the entire law related to a particular topic if you are not telling me act and rules together. Now, when I'm talking about this patent rules 1972, this was the first comprehensive legislation on patent in India, and it replaced the Indian Patent and Design Act. This is what was there. Most important part, what happened is that it said no product patent for medicine or food. So product patenting was taken away. So impact of this is, say, what happens is, if you have prepared a product, I cannot make it. But if you have patented a process, the end product can be made from any other process. So what is happening is, in medicine, why we went for medicine is simple. Because even if it is patented, I can use another process to make this, to arrive at this product. Because of this, our generic medicine market flourished. That's why we are leader in generic medicines. So the product patenting was stopped for medicines. Now, the term of another thing, 14 years in general, that term was there, not 20 years. And a short food and medicine used to have 5 to 7 year term. That is almost half. Now comes why this happened entirely. Again, please remember what is 1970. What is happening in 1970? We are still not out of the food security problem. We are a nation who just, from its infancy, the moment first we were looted, plundered everything by the British. That's when we got the nation, we were in a very bad shape. When we started to stand on it, we had our neighbors who were newly created, they were fighting with us. So we fought 3 wars until 1972. 3 wars. A nation who is fighting 3 wars and had just started to develop, it's like that you were robbed and then you are fighting with your neighbors to survive. When you at the same time, you don't have any support for food or anything else. Because of that, the focus was on the health to as a nation to survive and as a nation to have food, proper food. So we wanted to protect the innovation part. We wanted to protect you. Okay, there should be invention domestic, but we wanted that the exported innovation should not come to us. They should not come and get the patent and exploit us again. See, the foreign companies were, for example, British companies could have always come and asked for the patent in medicine because they are doing it. But the moment they get the patent in India, you will not be able to make. So, and to avoid all these kind of problems, because everyone we have already experienced that we have been exploited by a company. And after that, the crown which came, that was also not helpful for us. That has again exploited us. We lost our medicine facilities, our health facilities, our food security. Lots of events we have seen during the reign of British. So in total, we were suffering mainly in the food security and the health problem. So this act was aimed towards that I will encourage the domestic invention, but I will also prevent the exploitation of Indian resources by the foreign companies. Now, in 1995, things started to change. In 1995, what happened is WTO came into existence. It was World Trade Organization came into existence, and India was to become a member of WTO. They said that because thing was changing, we also went into the WTO. There was lots of debate whether we should go or not, but WTO, we entered, we became a member. Trade-related aspects of intellectual property agreement came into force on January 1, 1995. This date becomes very important. TRIPS, now from this January 1, 1995, we got a relief. What relief we got? We got that since you are a developing country, you can have 10 years to introduce the product patent for all inventions. The idea is that drug and pharmaceutical the product patent should be there. This was an international commitment demanded from us because every member has to do it. That they wanted a common standard for all the IP which have added, in which the patent term for 20 years was prescribed under TRIPS, which every country has to follow. And everything, product and the process, both should be patented and without any exceptions. Because of this, the grace period of 10 years to introduce the product patent for all invention was given to India. Now, see, in 1995, we got the grace period. So what we said, we will not examine any patent application from January 1, 1995 related to pharmaceuticals and others. We will create a mailbox provision because you want a product patent and the idea is that term should be 20 years. So what we said, okay, after 10 years we will check. So there is a mailbox. This is a mailbox. All applications related to pharma, come put it here. We will see in 2000 when we have the product patented. Okay, but meanwhile, these applicants will get an exclusive marketing right for 5 years. For 5 years, you can market. This was the provision which was made in 1995. Okay. Then another part happens. We also became a member in 1998 of 2 more major main conventions. One was Paris Convention of 1883, another was the Patent Cooperation Treaty. Paris Convention, under Paris Convention, what we understood is, we agreed is that we will give the national treatment to other contracting states. That is, I will have the same right as an American in US, and an American will have the same right to get the patent in India for his invention. This is the national treatment. Okay, I will not discriminate with the nationals of other contracting states. Then there was a reciprocity in filing with the right of priority. If any application is filed in your country, for example, in US, if you are coming here, you can claim that that date on which that application was filed, I can claim the priority of that particular date and file it here. So we agreed to that also. And then we find that right of inventor to be named, independent patent, and a right of inventor to be named. What was that right of inventor to be named is that whether applicant is inventor or not, inventor should be credited. You should know the name of inventor who has created that particular invention. Now, important part here is applicant and inventor. What is the difference? Inventor is the person who has created the invention. Applicant is the person who is applying for the patent to the patent office. Now, inventor can be the applicant, or inventor can assign his rights to the any other third person who can be the applicant. So this concept of assignment is coming in picture from the date of from the day you start filing. When we will go for the filing, we will start for understanding how the filing happens, who can file. There we will see how assignment works. For example, company is filing, employee has assigned their invention. Any professor who is working in an institute, any researcher who is working in an institute is assigning their right as an inventor to their university or a company only because of that assignment. On basis of that assignment only they are able to file the invention to the patent office. Otherwise they cannot, because the right has not been transferred. Now comes PCT. Patent Cooperation Treaty was that we decided, it was agreed in 1970 at Washington. Idea was that let's make a single window part like thing that anyone can apply through that window. If I apply through that window, I am applying to any jurisdiction who has agreed to it, and n number of jurisdiction, provided in national phase, it will work as if it was a domestic application. So, but please note, this is not an idea to create an international patent, but it is an idea to simplify the procedure, because Patent Act is a territorial act. It cannot extend beyond the territory. India cannot just create a law which works in US jurisdiction. US cannot create a law which is binding on the Indian soil. So the sovereignty of countries is necessary. That's why your right is also territorial. If you have recognized a right in India, so you will have the right of that practicing that patent in India only. Similarly, if you have a right in US, you have right to practice there only. You cannot claim your patent right here unless you are coming through this, either Paris Convention or PCT. Okay. Now, the third part, it is after 2001, but this is very important treaty, and it is also these Paris Convention PCT are defined in your Patent Act. Now, member of Budapest Treaty. We also became the member of Budapest Treaty. Why? Because we are going for patenting of everything. We said that. So we went for patenting a microorganism for patent process. So microorganism cannot be disclosed properly. You cannot describe everything, because this is a microorganism. So full disclosure is that you take that microorganism and deposit it someplace. So this is an international recognition or deposit of microorganism for purpose of patent procedure. Under this, various depositories in various countries have been recognized. In India also there are depositories. So you have to deposit your microorganisms which you have created there, and on basis of that, your application will be filed. That number which you have got, you have to give in this application number, so that anyone who wants to know about that microorganism and this, there is a sample deposition of microorganism at a particular place, which is a full disclosure to understand your invention. Now, then Patent Act 1970, in this background, which is happening in 95 to 2000, 2001, various amendments came. In 99, Patent Amendment Act 1999 came. Then Patent Amendment Act 2002 came. Then Patent Amendment Ordinance 2004 came, and the Patent Amendment Act 2005 with effect from 1/1/2005. Please remember, in 1995 we entered, and we made all those provisions, EMR and those things here. And in 1/2/2005, we went for another Amendment Act. So all this was to comply with TRIPS obligation, commitment and international treaty in phased manner in 10-year timeline provided to the developing nations. So this all we did. Then we comes to, this is the, in 2005, the main Amendment Act, what happened is that we extended product patent to pharma, food and chemicals. We also went for software protection if the software is in combination with the embedded with the hardware. Hence, we said that software per se is not patentable, but if software is claimed as in combination with hardware and other thing, it can be patented. Then comes the grant of compulsory license. Please remember, compulsory licensing was earlier also. So what we brought the compulsory grant of compulsory license for export of medicines to country with insufficient or no manufacturing capacity. Then we came to national security provisions specific to dual use technology. Here my question is, what is dual use technology? Any idea?
No, sir. Don't have any idea.
I was expecting an answer here because we have people who are aware of that. I think you are not aware of dual use technology. See, dual use technology is that which has two kinds of purpose, as name suggests. First is defense. Second is civilian use. If there any technology which has a civilian use as well as defense use, that is considered as a dual use technology. Hence, there should be a national security provision. Example of dual use technology: missiles and GSL both work on the same principle. So, see, if you can send it to, if you are sending it straight, it's going for exploration of moon and other things. If you are saying a little, you change an angle, it can work as a missile. So this is what dual use technology is. Nuclear technology. You can create a nuclear bomb out of it. You can create a nuclear energy. That is also a dual use technology. So when you will study the act, you will find nuclear exceptions, defense exceptions, secrecy provisions. All those are because of our concern with the national security. Then in 2021, Tribunal Reforms Act came. It was from 4/4/2021. What happened is government has gone for there was a time when everything was that we will create a tribunal, we will lower the burden of the court, and that's how it is. So to lower the burden of court, IPAB was established, and it was Intellectual Property Appellate Board. So all this, whatever is happening in registrar office, when you are going for, all that could be appealed to this body, not to a court. However, now they have found it was not that efficient. It has not reduced any burden. It has not reduced the cost. Instead it became costly or ineffective for that. So they decided that we will remove it, and they brought back the High Court as an appellate body again. Now High Court is an appellate body. Then comes Amendment to Patent Act 9. This one is a Jan Viswas Amendment of Provisions Act 2023. This is the
Hello, sir.
latest one. Yes.
Sorry for interrupting. Dual use of single patent you are talking about. It would
No,
clearly.
technology. I'm not talking about the patent. I'm talking
Okay.
about what you understand by dual use technology. See, if you have patented and the patent is in the domain of dual use technology, for example, you are claiming civilian use, but you are not, use is not being claimed here. Na? It is the invention which is being claimed, though you are structuring it as a civilian use. For example, it is related to something which can GSLV, suppose. So if that technology, projectile technology you are talking about, in which can also be used in defense for as a missile technology, then that invention falls under the domain of dual use technology, and defense has to think on it whether and it should get a patent or not. Government has to think on it. It has to weigh, they have to make a fine balance of national security as well as inventors' right. Because the
Okay, sir.
moment I publish it, everyone knows about it. So,
Okay, sir. Got it.
got it? So
Yes,
that's why we go for secrecy provision. Even if that is, if I found that this is related false under this domain, for example, we say that if it deals with nuclear energy, thank you very much, we will not give you a patent. No patent. Why? Because patent has a first reason to publish the patent, disclose it to public. I don't want it to disclose it to public. So for national, anything which is dealing with nuclear is out of the question. Then comes dual use technology, which might have a defense implication. We say, okay, if government agrees, we will go for the patent. This is the provision. We will discuss it when we are coming to application and publication. We will discuss why secrecy provisions are there now, but they are coming from this necessity. Now comes Amendment to Patent Act 1970. This is just in August it has come. It has been notified on 11th August 2023, but it has not been enforced because it is amending various acts, and every act falls under different domain of ministry. So as and when they are prepared, they will provide for this notification of that. So our ministry will also provide, yet it has not been notified. I tried to search if I have been notified. I could not get. Please keep track of it. If you get to know that this has been notified, please remember that date on which it is being notified. Fines and penalties. The idea is it deals with Jan Vishwas Act deals with this penalties and offenses. So there is a chapter 20 which deals with the penalties. In this, various sections have been modified, and one has been deleted and two have been added. Okay, and the General Act says that all the fines and penalties which are prescribed will be increased by 10% of the minimum amount of fine or penalty every 3 years. That means what is happening is some, for example, 1 lakh rupees was prescribed as a minimum, and maximum was prescribed as a 5 lakh. So it is there till it is getting it gets amendment. This act says no, every 3 years 1 lakh will become 1,10,000. And similarly, the higher amount will also change. So this is how it will increase, so that inflation also is taken care of it. I understand that why the penalty is, because if I stuck to a penalty, if money is getting devalued, inflation because of inflation, then the fine does not make much sense. Because what was 1 lakh, what was 10,000 in 1970 is not 10,000 in 10,000 does not have that kind of a value or deterrent effect in 2023. That's why. So changes in this or this, please note whenever this kind of a change is there, a MCQ can be there we can expect MCQ of 3 marks. Key Chan Viswas amendment, what amendments have been done, what has been deleted, what has been modified. When we will be discussing that penalties, I will be giving you a short notes on exact position of the penalties which you have, because books will also not get this fast amended. Your Bare Act will not have that. So we will keep an eye on this. So this was the entire session on the evolution of patent law in India today. Okay. So let's come to this. Any questions?
Sir, I think it is not related with that our exam, but all time I have one question in mind. Like who is in like you are just giving example as a nuclear energy, like that kind of thing. So, sir, for the secrecy reason or any other thing, like also in that our section 3C, I think the discovery things, like for that or any scientific principle, it is not possible for patent. So if so, sir, they are also contributing, but they are not in return. They are not getting any money because for some reason their invention will not be possible to patent. So, sir, is there any compensating thing parallel is going on for them? So who are inventing like basic principles, but that is not possible. But if any doctor um, inventing any surgical method that is not possible to patent. So I am wondering, like that question comes in my mind that it is not patentable means they are not getting money. Other people by using that thing, they are getting money. So, sir, is there anything?
The first thing is, let's go back to our basic understanding. What we said, you don't have any right to your invention unless you disclose. This is the first thing I am saying. But
Yes,
this
sir.
right is a statutory right creation. This creation is by government. It was not before 1910. This is a new creation. This is a right which I have created now. So depending on the situation which I feel is important for nation, in the way nation, you can say the state of nation, the circumstances in which nation is, legislature has decided that this should not be patentable at this moment. Will this continue or not? We don't know. What you are saying is correct. But at present, who is doing the research in nuclear energy? Actually, government. Government is mainly focused on that particular part.
Okay.
Then comes the curative and the surgical method and other things. I will say another concern is their health concern. See, think on those points. Money is not the important part. The statute is not for giving you money or compensating you. Statute is to make a fine balance between two things: need of society and your invention. If your invention is beneficial to me, then, and by recognizing by your right, I am helping my society, then yes, I want that you get compensated. Suppose you are saying that I have created, a doctor has created a surgical tool and it is not patentable, but no one has stopped him to practice that as a trade secret. He will not tell it to. He does not have an obligation to disclose also. He can continue, correct? That doctor has a different procedure and he is doing it and it has a better result. That we can always continue as a trade secret. Because
Okay.
I'm not stopping a trade secret. That will be a confidential information. You continue, you make money. You don't disclose it. What I am saying is you disclose it if you want a protection. It is a voluntary disclosure. You come to me. If you say that you have an invention, you come to me. I will identify whether you need whether your invention deserves a monopoly or not. There are certain criteria on basis of which I'm giving it to you. This is how it is. So consider it like this. The basic understanding is whether society will be benefited or not. If society is benefited at a loss, or there are certain things on which we consider that society will not be benefited but have a problem because of recognizing these kind of subject, then we have stated that we will not recognize that. But at present, the law is like this. Law can change. I think Rajesh, can you please? Yes, Rajesh.
Sir, what is the current status of pharma patent in India right now?
Pharma patent is allowed. Product process both.
Okay, in India, so it is
Sorry.
like most of the companies, like generic companies, are there in India. They used to sell their product outside. So whether it is applicable in India also, this we have went for a TRIPS agreement and all, said PCT and all. So that's what I'm asking.
Generic at present, if the simple thing is generic industry works on the one thing. Either your patent is expired or your patent is not in the jurisdiction of India. You have not taken any patent in India. This is the two places they will work. So if you don't have a patent in India, thank you very much. They can practice. If you have a patent in India, you are not practicing in India, they will go for compulsory licensing and get the job done. The thing is, generic medicine or anything, or suppose I can manufacture in if I suppose in Africa, it is not protected. I will create that particular factory there, form a new company there, and make the medicine there, because you are not protected there. So generic medicine will find their way and they will do it. What is happening? That's why if you go for WHO is gaga about India. Wow, wow, wow. कितना बढ़िया काम करते हो, medicine बहुत सस्ती मिल जाती है. They are very happy. US is not happy. Africa is very happy with you because you are the one who can give them cheaper medicine. So everyone is somewhere benefited, somewhere having a problem. Ananya, please.
So, as you talked about patent rules and the process, how can it be amended or who can make the rules? So, what are the steps for if someone or anyone want to any suggestions or amend the rules? And you have told that should they will have to DPIIT should officials will have to present in a court. And in that case, any court, any district court, no, high court you have told about. So any high court will be fine.
I don't understand. First, let me get back to the question. I got messed up. Are you talking about rule making power?
Yes, sir. Yes, sir.
So rule making power, court has no rule. Court has no role to play except if that High Court has a jurisdiction over it. See, High Court have a right to conduct their proceeding. They make rule how you will approach. See, simple thing is, for example, you have a form. Forms are what? Forms are a template given to you that if you are approaching IP office, if you are coming to me, how you will present your case to me. So these are the requirements. These are the main features which you should tell me so that I can address your query or act upon your request. Because otherwise everyone will be doing everything. Now go to High Court. High Court also go for the same thing. If you are coming to us, your petition should have this formality should be completed. It should be one-sided printed, two-sided printed. It should come in this, half should be written, half should not be written. That kind of a rule is always there. So this rule making power is restricted to their proceeding. High Court will make rule with their proceeding, while government will make rule with entire subject matter, which is written under the power of central government to make rules. That is there. Okay, so these two rules are very different. High Court is not making any rule for everything. They are making rule only with the proceeding related to which is coming to their court. How you will approach their court and how they will order. That is the only thing which they govern, nothing else. There was one more person who wanted to ask. I think Shailendra, your mic was on. Yeah, Shailendra, you are on mute. You want to ask some question? Okay, so this is done. Fine. Hope just go. I will share this slide to you with you. You just go through this. I have taken this information from IP India site. Please visit this site, ipindiagov.in. This one. So this official site, please visit. You will get lots of things here. Resources is there, the manual guidelines, controller decision, everything. So you can see patent rules. Yes. So draft amendment. This is a draft amendment rule which we have published in Gazette on 22nd August for objection and suggestion. Draft rules are not relevant for exam. Why? Because in my understanding, what has been, it is not finalized yet. Everyone is just trying to give their opinion at present. This will not come. A little concrete thing will come. For example, Jan Vishwas Amendment Act, that will come. You should prepare because that change has come, whether it is notified or not, but change has come. It is a matter of time that it will become effective. That's it. So go for that, and don't worry about many questions on this, because while I'm going for discussion, I will be telling you this. In patent manual, I think last time I told you that you should go for this appeal part. You should leave. Okay, the appeal part of patent manual leave. Now you leave offenses also, offenses and penalty also. The reason is this act has changed that penalty. So whatever is written there is not that relevant. You might get confused. So don't touch penalty part chapter and don't touch appeal chapter. Okay. So this is how you go through this. I don't think anything else. One more thing which I wanted to emphasize. I have written in a WhatsApp group also. Please use pen and paper. Start using pen and papers. Otherwise, it will be very difficult for you to complete your entire paper there. These 2 months, start writing. You read, you write, you create flow charts, everything. But start using pen and paper. Computers have spoiled us. It is very problematic if you go there and you don't get to perform. That's all. See, so start practicing and practice in a rule page, because as I've shown you, the paper will be ruled. So you start writing and try to understand in one line how many words you write. That will give you a basic idea in one page how much you can write. That will help you in answering 5-10 mark questions easily. Right? So all this calculation will help you there in completing entire paper in less time. This you have to start practicing now only. So you start doing it, and whatever I have told you in extra, please make notes of that. Okay, because that is not included in the slide. Keep bona fide active, that quid pro quo thing, act and rule thing, assignment and license things, because everything will start coming, and again you will be revising that. It will help in your understanding, because questions are application based. If you have basic understanding like this, then you will start thinking on it, and you will be able to answer the questions better. Thank you. So I've taken a 20 minutes more. Next time I will try to compress it much. Next class is on this on today's Wednesday, on Friday. So one day you have go through the whatever you have studied. If you can read about the evolution of history and this as anywhere in the site itself, you can get the basic understanding whatever I have told you. And rest again, this will be revised. One more thing, I will be starting with the patent life cycle in the next class. First, I will give you a brief of patent life cycle, entire life cycle, and how you should look at the Patent Act so that everything starts falling in place. Then we will start with the application part, how an application is filed, and novelty, inventive step, and uh, other substantive part we will deal when we will be discussing the examination. So my pattern is a little different. I'm not, because everyone starts with a patent. I have seen people say section 3 तो पढ़ा ही नहीं हम आगे चले गए. नहीं, section परेशान नहीं होइए. What is patentable, not patentable, we will discuss a little later, because various jargon and various terminologies have to be completed first to make you understand novelty and inventive step. Otherwise, it cannot work, because if I talk about complete specification now, it will be difficult for you to understand. So, considering that, this is how this will be like structured. Okay, that's all from me. Have a good day.
Thank you, sir.
Good day to you, sir.
Thank you, sir.
Bye.
Thank you, sir.